What kind of cases can magistrate court hear? Magistrate courts can hear civil cases. Magistrate courts are authorized to hear a variety of civil cases as long as the amount of damages sought does not exceed the amount of $15,000. Specifically, magistrate courts hear suits on accounts, suits for money owed, cases involving contract disputes, cases for injuries to persons or damage to property, personal property foreclosures, garnishments, levies on property to satisfy a judgment, post-judgment discovery, and actions regarding abandoned motor vehicles. In some cases, magistrate courts hear distress warrants, which are actions filed against individuals or corporations who remain on a property without the legal right to do so. Magistrate courts also hear dispossessory or landlord-tenant actions involving non-payment of rent. However, the $15,000 jurisdictional monetary limit does not apply in dispossessory actions for rent owed, as there is no jurisdictional monetary limit in dispossessory eviction cases. Magistrate courts can hear criminal cases. Almost all criminal cases begin in the magistrate courts. Magistrate court judges have legal authority to issue criminal arrest warrants for both felony and misdemeanor offenses. Magistrate court judges are also authorized to issue search warrants upon the sworn testimony of law enforcement officers. In addition, magistrate judges have the authority to issue what are referred to as good behavior warrants as a way to keep the peace and ensure that one person's conduct will not cause another person any emotional or physical harm. Further, magistrate judges have the authority to issue citizens' warrants after a citizen has filed an application for what is called a pre-warrant or warrant application hearing, seeking the arrest of a person, and only upon the magistrate judge finding probable cause to issue an arrest warrant after a hearing. Magistrate courts also conduct first appearance hearings, preliminary hearings, and waivers of extradition hearings for the purpose of giving an accused his or her rights, considering appropriate bond matters, and determining whether probable cause exists to allow criminal cases to proceed to either the state or superior courts for trial. Magistrate courts also conduct first appearance hearings, preliminary hearings, and waivers of extradition hearings for the purpose of giving an accused his or her rights, considering appropriate bond matters, and determining whether probable cause exists to allow criminal cases to proceed to either the state or superior courts for trial. In some jurisdictions, magistrate courts hold trials for those defendants charged with violations of county ordinances and certain statutorily designated misdemeanor offenses, such as deposit account fraud, shoplifting, possession of marijuana, trespassing, and alcohol offenses by persons under the age of 21. What kinds of cases cannot be heard in magistrate court? Magistrate courts do not have jurisdiction to hear trials related to felony offenses, most misdemeanor offenses, temporary restraining orders brought or TPOs, seeking relief pursuant to the Family Violence Act, divorce cases, child custody, visitation, and support matters, real property or land cases, and mental health commitments. Magistrate courts also cannot hear matters involving equity claims, which are those claims where a party is asking the court for an order directing a person to perform a certain act or to refrain from performing a certain act. You can find more information about the jurisdiction of magistrate courts in Chapter 10 of Title 15 of the Georgia Code.